welcome to the second in the series of the 2020 CPJ webinar series. I'm glad you're all with us today. This one is going to be on the ALTA NSPS land title surveys. We've got a good group and a diverse group of people participating today. Ultimately, we're going to have about 50 or so on the Teams conference here, but just to give you a sense of who is listening on the line, we've got about 10 different attorney firms, 3 different title companies, about 15 or so single-family housing builder developers, a multifamily client, 8 commercial builders or so, a couple of real estate folks, 9 land development folks, and 3 commercial developing firms. So a lot of good, diverse participants on both sides of the ALTA survey front. Before we get started into the program, if you're new to Teams, just go over a couple rules right here. Hopefully we don't need to see your video, so your video should be off. If you put your mouse across the middle of the screen, that floating toolbar, your microphone should also be muted. No need for you to share your screen. We will have an opportunity for you to ask questions. So there is a show and hide conversation, second from the right, well, next to the hang up button here, that you can type a question into that area. We'll see that and we'll be able to answer that at the appropriate time. You can also see the participants button. So preferably keep your microphone muted, and then we'll be able to address the questions as we plow through the thing here. Again, welcome. My name is Steve Jones. I'm a professional land surveyor in Maryland, DC, and Virginia, and in charge of our Maryland Surveys Division. I've also got on the line Gene Dorn. He's my counterpart in Virginia and covers all the Virginia stuff. Coming to you live he's out in Fairfax. I'm here in Silver Spring. Gene?
Yes.
So, Gene is on the line with us here.
Yes. Did you want me to expand a little bit on my qualifications? Sure. Or?
Yeah, just keep it real quick.
Okay, well, I've worked for probably 40 years in the surveying industry, and most of that has been here in the Northern Virginia area, and done hundreds of ALTA surveys, and hope to do a lot more.
Okay. I've got about the equal amount of experience over here, about 40 years. So between Gene and I, we bring about 80 years to the table, and no shortage of ALTA surveys between us. So on your screen right now, you'll see that some of the things we intend to cover today, we're going to review the 2016 ALTA standards, how we got to where they are now. I'm going to include a couple items about critical proposal language. You may see if you receive a proposal, depending on where you are in the process, this may not be germane to you. I give this talk to quite a few different audiences. This is a pretty diverse group. Quite often I'm talking to a bunch of other surveyors. And so we'll briefly go over what has to go into preparing an ALTA survey, part of the quality assurance, quality control process, what I call perils and pitfalls. And then as always, there'll be some updates. And so we'll talk about those real quick. So for everybody's benefit, the ALTA surveys have been around, and the standards have been around since 1962, and you can see some of the critical and key dates. They weren't always updated on a regular interval, but of late, I would say, since 2005 or so, they've been on a 5-year cycle. And so I've got some question marks and a little teaser line. So 2021's coming up. There'll be some new standards then, but we'll talk about them at the end of the presentation. I did put the link on there to get a copy of the ALTA standards. This, what I call my playbook. This is not only direction to the surveyors, but people who use ALTA surveys. So I keep this thing within arm's length of my desk all the time. It's a concise 11 pages. The first 8 of which are the direction about how to prepare the survey. The last 3 talking about the table A items. We'll cover those as well. If you've been in the business for a while, you may have known ALTA surveys be called ALTA ACSM. ACSM is the American Congress on Surveying and Mapping. That was a group that dissolved. It was a member organization that dissolved a few years back, and the NSPS organization, the National Society of Professional Surveyors, who was one of the members, stepped up and became the partner with the American Land Title Association in the renaming of the survey. So if you see anything with ALTA ACSM on it, it's probably dated information, especially the standards or table A items, that sort of thing.
I think that there are about 10 members from ALTA on the committee and about 15 surveyor members from NSPS that make up the overall committee that comes up with the new standards and keeps them up to date.
All right. So the short, concise question might be, what is an ALTA survey? We hear the term bandied about quite a bit. But so I came up with my 30-second elevator speech. And so this is if you're telling somebody else what happens here. But Gary Kent, who leads the NSPS committee on ALTA survey and reviewing them periodically, and I had just talked to him not too long ago, had come up with a pretty good preamble as to why and what ALTA surveys are. And basically, he starts out by saying, in the United States, there's no guarantee of ownership of real property. A deed is, in fact, only proof or not proof of your ownership of real property. It's only evidence that you might own it. So overcoming this problem and being able to confidently buy real property or to obtain a loan, some sort of assurance that one has that one's investment isn't at risk, the way to accomplish that is with title insurance. And there's not a bank that I know in the United States that will lend money or to purchase or develop real property unless it's provided a title policy in order to ensure that its investment, the real property, which is collateral, the lenders will require that the standard exception to coverage, the standard survey exception, be deleted from their policy. And so the exact wording of that language may vary, but it may be read something like an exception for any claims or parties in possession, boundary line disputes, overlaps, encroachments, and any other matters not shown by the public records, which will be disclosed by an accurate survey and inspection of the property. That's where the surveyor comes in. So once the survey is produced, then the standard or the blanket survey exception comes off, and then you can get into specific objections where there may be the lines of possession may be inconsistent with the title lines and that sort of thing. And we'll touch on a little bit of them later on. The long and short of it, I tell people all the time, and we'll identify some players here in a minute. If the lender ain't happy, ain't nobody happy. So the survey, the ALTA survey standard is broken into very simple 8 parts. It was reformatted on the 2 go-rounds ago to make it more user-friendly, and they've done a very good job at doing so. And so it talks about the purpose, the request, and we'll talk about each one of these a little bit: survey standards, the records of research, field work, the platter map, certification, and the Table A items. So the reason we have this survey, like we just talked about, is there are going to be certain players who are requiring this survey to address title issues, and it provides for a standard format for the presentation of the product to make sure that the items included are there, that all the items have been addressed in a uniform and standard manner. So when a request comes for the survey, more often than not, they come to me by email or by phone call. And the first thing, I've got a handful of questions in my mind that I need to ask to identify the particulars so I know what all is involved. And I go back to and I talk about who are the players all the time. So there's certainly the lender, the borrower, who is normally who the survey is going to work for. They're also known as the insured, the borrower's attorney. You may get a call from them, not the borrower, the title insurance company, and then the surveyor is certainly a player. So more often than not, you're going to deal with the borrower since they're paying the freight, and the borrower's attorney. But don't assume that all the borrowers that you're dealing with or all your clients are as versed in the survey and the ALTA standards as you are. They're relying on you, the surveyor, or I should say me and Gene or the surveyors, to give everybody the heads up on what's needed and all that sort of stuff, and to go through the requirements. First and foremost, too, might be, who do we send the proposal to? Who's paying the freight? Whether it's the borrower or their agent or whoever it is. We talk about what are the limits of the survey. Quite often I get just a property address on this road, And then as I do some research, turns out that property and the piece next door are owned by the same entity. So the ambiguity exists when just an address is given or just a parcel if you're doing some research. So ideally, you receive a copy of the title commitment, and it outlines the property to be insured, either by lot and block, by parcel, by description, in some fashion or other. It's supposed to uniquely describe that property separate from all others. Gene, do you want to weigh in on that one?
As to the property, I rely on the title report to define the exact location of the property and what the property is.
Quite often, I'll bet 50% of the time, the title report or the title commitment is not the first thing I get. And so just to be clear for everybody on the line here, you'll hear title commitments. That's the final document that identifies the various players, although some may not be fully known at the time, the description of the property and the standard, all the standard exceptions, and then the specific survey exceptions. So those are all identified in there. I don't get that all the time up front, so you have to ask all these questions and make sure you're covering all of what is intended to be surveyed. And then I ask, why do they want the survey? You may ask, why is that a big deal, Steve? Typically, I've identified 4 main reasons why people want an ALTA survey. They're either refinanced by the current owner, there's a transactional survey from one party to another, it could be a pre-construction survey, or a post-construction survey. Those are the 4 big ones I deal with. The one that raises the most flags for me is a pre-construction survey, because when we talk about the ALTA standards, I need to address accuracy standards, my tolerances in distances from improvements to the property line, or the accuracy standards to which we're dealing with. If the existing conditions are a gravel parking lot, but the proposed conditions is to put a building on that property, I need to address probably a tighter accuracy level. If there's no, especially if the improvements are intended to span the entire property or become very close to the property line. So your accuracy levels, don't be surprised when they say, why do you want the survey? And so it's going to be generally one of these reasons. Where the property is, quite often.
Could I jump in, Steve?
Sure.
Right now in today's environment with the really low interest rates, I'm finding a lot of ALTA surveys are being required for refinancing.
Definitely that. I do quite a bit of apartment surveys for refinancing. They could be intending to develop and put a new building on the property. I work with plenty of land developers and home builders on acquisition surveys for properties they intend to acquire. And not to get too far off the track, they may identify an entire property, but some builders and developers only take down certain lots that may not be platted yet, but they're under the process of being platted. So sometimes all the pieces aren't static, but they're in play. So you want to be brought on board as soon as you can, so you're a partner in the effort, not late to the table. So that brings me to the last thing, is when do they need it? I don't know of any survey, well, I'm going to try to get away from saying never say never and always, never do the extremes here, but more often than not, there is a due diligence period, of a study period, or a feasibility period that your client knows about. Hopefully they give you the phone call or the email as soon as they know when that is. I've gotten plenty of phone calls when they say my due diligence period ends at the end of the month, and I've got 25 days to perform, or I may have 3 weeks or 2 weeks. So you come late to the table for a variety of reasons, and the sooner you're brought on board, the better. It may turn out that their request may not be able to be accomplished in that time frame by you, and so you've got to know up front what you're in for, and what the deadlines are, because a lot of money is riding in the balance on people hitting these due diligence or feasibility periods, and they want to know up front, can you perform in that time period? So you're really trying to get up to speed as quickly as you can. And the standard ALTA survey may be doable, but depending on what table A items they want, and we'll talk about them in a minute, that may drive not only cost, but timing of the survey because of the effort you have to do. The other player I didn't identify up top there, HUD. if you've got, you know, you're going to package this thing up and it's going to go to HUD, then that automatically drives the bus on certain Table A items that need to be included. And it's going to include the surveyor's report, which most of you are familiar with, that needs to be submitted when we package everything up and go to HUD. And they have their review process. Let your surveyor know as soon as you can if there's going to be a HUD survey.
And they usually have a more extensive surveyor certificate that goes on the face of the survey.
So for the folks who practice in Maryland, if you're a Maryland surveyor and the property is in Maryland, then your Maryland surveyor has to perform to the COMAR 9130612, which is our business practices statute, which is basically to try to keep the surveyor out of court at the end of the process. And as it says right here, you know, you're supposed to discuss with the client at least a handful of items here: the type of survey, the limits, the specific survey services to be provided, the approximate completion time schedule, and agreement for payment. More often than not, contract disputes aren't over the contents of the survey. It's over a breach of the agreement or a missed deadline or something like that. It's a contract issue, less of a survey issue. So we talked about Table A items. So the ALTA standards, now that you've all downloaded it from the link I gave you here, prescribes certain things I need to do, with the big effort being on easements and servitudes that burden or benefit the property. But the additional items a lot of people may think are standard items are all listed on this page right here. So unless it's required by the local municipality or jurisdiction, and local jurisdictions, if their restrictions, if their laws are more stringent than the ALTA standards, then the more stringent restrictions apply. But if property corners are discussed and they might ask to be set, they may want to specifically see where the lines are, or they may not be included necessarily. If there have to be some property corners found to establish where the property is, but maybe all the points don't need to be set. But it should be discussed or identified if people want it. You wouldn't think the address was an optional item, but it is. Flood zone category isn't included by default, but if you need to know if you're in the 100-year, the 500-year floodplain, or any other special flood hazard area, that should be indicated on the Table A items. Land area, I think, would be a no-brainer, but that's not standard, although most surveys I know would include that on there anyway. You can get topography added to the survey. I know plenty of clients that use these surveys as pre-development surveys. So not only do they get the topography, they get the boundary and all the exceptions and easements listed on the one document and get everything squared away at one time. Zoning is a huge item. They break zoning into what zoning category am I in, and it can get more extensive, which requires a zoning report to identify setbacks and other restrictions. I go back and forth on this item all the time. You need to make sure you understand or convey to the surveyor, and likewise the surveyor needs to understand which of these items need to be included, and then correspondingly that zoning report needs to be solicited from the appropriate jurisdiction and provided. And then the surveyor's responsibility is to show these particular setbacks when there's no ambiguity. A lot of times setbacks are based on height of the building. And so there may be, if it's a proposed building, it's not built yet, then those setbacks may be floating. But ideally, the surveyor can address the zoning information from the zoning report when it's provided. Quite often parking is an issue, numbers of spaces, that sort of thing. And then, there's a 6A and 6B, are very important. Building information can be broken down into distance around the building at ground level, the building footprint area, if that's an issue, site features, signs, and so you would think that would be a standard thing, but site features generally are included on my proposal. You want to see what's on the property. That's why you're ordering the survey. Parking is included. We'll designate the regular spaces, the disabled spaces, motorcycle spaces, all that sort of stuff. In certain jurisdictions, party walls may be of concern. If you're dealing with row houses or property lines where there may be a party wall involved, and not only that, the wall, where the wall is relative to the line, but is that wall plumb? Utilities is probably the next biggest item, I think, of the Table A items. By default, and as a standard of the ALTA survey requirements, I, as a surveyor, have to show any evidence of utilities on the property, visible evidence utilities. So if there's overhead wires, missed utility paint marks, gas valves, water meters, sewer cleanouts, all those types of things, I need to show, because those are evidence of servitudes on the property, which is one of the fundamental reasons we're putting together the ALTA survey in the first part.
And
But
Steve,
yeah,
and Steve, I was going to say about the utilities, that was one of the differences between the 2011 standards and the 2016 standards, was it used to be the observable evidence of utilities was all included in this table A item, but now it's in the body of the requirements that you locate observable evidence of utilities. And the reason for that is because it usually, and many times, it indicates the existence of an easement.
and conversely, it may indicate the existence of the evidence that there's not an easement for a sewer line or a storm drain line. So utilities on a property without the benefit of an easement, whether it's a specific easement or a blanket easement, are flags to people reviewing title and reviewing the survey. The second part of the utilities now that Gene talked about, that now is only the table A, item 11, is you may be asked to have a third-party utility designator, subsurface utility engineer, do some designation to find out where certain utilities are that may not be visible, especially dry utilities that may not be evidence, or the ones that have angulated directions without the benefit of plan. Sometimes older documents may be a blanket type of easement or in a general area, and you want a sense of where the all the utilities are. So there may be a need to bring a third party on at a separate fee, but can be included in the proposal. But utilities are a huge item, but the visible utilities get covered in the standard ALTA survey. We talked about the government requirements. If HUD's a player in the survey, make sure your surveyor knows that up front so they can address, get geared up for the survey's report, which they know they'll have to do. And there's different types of those. There's multifamily, a couple different HUD reports. They usually, HUD as an entity usually has been pretty good on the last go around. They do update their standards in line with the ALTA, NSPS organizations. They did in 2016, and hopefully they'll do the same in 2021. Adjoining property owners, all lines being surveyed have two sides. There's a side that we're working on, and then that line is shared by another. So the adjoining property owner information is supposed to be provided by the person requesting the survey, although most surveys I know have a lot of their own resources and jurisdictions that they work in. But just knowing that those are, if requested, should be provided by the person ordering the survey. Distance to the nearest intersection, because a property may exist along a long road, and you want to give people the idea of where the property is relative to the nearest cross street so they can find the property. Because it may be coordinates, but this is just a on-the-ground exercise to make sure people know where the property is. Item 15, we're going to talk about surveys being done on the ground, which by default is the presumption when you do an ALTA survey, although you can incorporate other sources of data and orthophotos. Orthophotos means they've been rectified and may show ground improvements either in coordinates. There have been some firms, title companies that dabbled in offering some of these recertifications based on aerial imagery only. I find that a very scary event that, of course, talking with my surveyor hat on, I would always recommend that people get a survey, an ALTA survey update or a survey performed by a surveyor, so it's performed on the ground. There are different sources of data as well in this ever-evolving electronic data. You may find LiDAR data, various communities have GIS data that can be used if that conversation is had with the client. Evidence of earthwork is always one we do on. Sometimes some of our surveys are done on active construction sites, and a simple statement may be that the site's an active construction site. Earthwork, moving activities are in place. Here we go. We're talking about all optional items here. Changes in street rights of way. quite often you'll see in jurisdictions where there's a planned master highway on a plan that may or may not have constructed, and it runs right through your property, or if you've got proposed dedication areas, or in certain jurisdictions, District of Columbia, where they may have alleys that were closed and that sort of thing. So changes in rights of way are important, but if you want the survey to go down that road, it needs to be identified as an extra item 17. Wetlands, if you're going to develop your property, clearly you'd want them located if that's going to impact development. That surveyor may or may not do their own designating, so they may have to have that contracted out. But if you want them on there, or you want them to certify to that, then you'd include item 18. The ALTA standard is different on these last couple items. There used to be, they had off-site easements that benefited a property, could have been an access easement to get to a property. Sometimes they need to be identified, and it's quite often in the description, you'll have a description of the property, and then the last sentence will be together with the right to use this property to get to, and describe that piece there. So there was also, it used to be an option to monument that off-site easement piece, and they took that out of the 2016 standard. So you may be asked, the survey may be asked to identify these off-site easements, whether they're for the operation of the property. It could be a utility or an access. Professional liability insurance, people may want you on, you may request, or your lender may request, or the builder may request higher liability insurance coverage. That's not something that goes on the survey, but it may be requested, and those agreements are had outside the face of the document. And then there's the option, the last item, which is blank. You can include any other negotiable items that aren't specifically enumerated in the ALTA Table A items that you want to. You can say the survey must be done within 3 weeks, or you can say, you can add any other items into that Table A that you want to. Hopefully that's on the survey's proposal, that's properly executed, becomes the contract for the survey. Gene, do you want to weigh in on any of these other here?
I guess one would be the professional liability insurance. In many cases, your client wants you to increase that over what your standard liability insurance is, and that's something we as surveyors and engineers can work out with our insurance carrier and pay an additional fee just for that one job.
Additionally, quite often I find that the person ordering the survey isn't nearly as well versed as other folks are, and they may not know what Table A items they want, but they want your proposal right away. So you really have to, as the surveyor, it's the onus is on me to make sure you convey to me, and then I ask of you which Table A items you want, because not only does, like I said, does it drive the timing of the survey, has a direct bearing on the cost of the survey as well. And so all those should be negotiated. And I put all these in my contract that I send out to people. So that leads us right into our critical proposal language. So on proposals you get from me, I'm going to ask you for copies of the most recent title commitment, the record description of the property to be surveyed, and other documents known as documents of record. Additionally, I should be asking for any private surveys that may exist, that are known to exist, that may not be recorded in the land records. I'm going to ask possibly for previous boundary surveys, because in our jurisdictions here, Maryland and Virginia, unlike some public land states, they require you to record your boundary surveys. Maryland doesn't have that requirement. In certain jurisdictions, you can record a boundary survey, but more often than not, they're just a private transaction between the owner of the property and the surveyor. They don't exist anywhere outside of those circles. They don't get recorded anywhere. So if you're ordering a survey and you're dealing with your client, ask if they've got a previous survey, whether it's a boundary survey or maybe a previous ALTA survey. And then in addition, we talked about some of the Table A items. If you want zoning information, make sure a zoning report is ordered. Sometimes those take 2 weeks, sometimes they're 4 weeks. And so those will have a direct impact on the deliverable timing of the survey.
So the situation you just discussed about recording ALTA surveys is the same here in Virginia as it is in Maryland then?
Yep. And likewise for DC too, there's no mechanism to record the survey. So these exist in the private world, but should be asked for by the surveyor, or you may be on the hook to acquiring it from the client. Additional language, this, I put my certificate right in our proposal. So, and I'll identify the parties that I know when I know it. So the if the insured name was one of the party, what the name of the bank, the title company, and the various parties or whatever entity name, LLC it is. And then based on the discussion we've had, I'll include my specific Table A items in here so that there's a clear understanding or a meeting of the minds as to what was ordered, what was offered, and then correspondingly the acceptance side to complete the contract. And then this is the required and the only allowable certificate on the survey according to the ALTA standards. We'll get into an exception to that rule, but more often than not, you'll see just the one survey certificate and then include specific Table A items. It doesn't have to include any of them, but more often than not, there'll be some Table A items in here, and I do recommend some basic ones like the property area, the distance to the intersection, and a handful of ones that I think are standard that don't adversely affect timing or cost of the survey. So just to briefly touch on what the survey may go through, there is a required standard of care. I've got certain methodology I need to use. I've got certain accuracy standards that are required by the ALTA standards. I need to understand the difference between precision versus accuracy. I can have a very precise survey, but if it's in the wrong spot, I'm not very accurate. If I didn't get the coordinates right or the boundary right, I get a very accurate survey, but if it's not very precise, it hasn't really served my client. And I'll make certain statements about the relative, the coordinate derivation, my relative positional precision, and allowable tolerances. There's a pretty lenient tolerance. The ALTA survey, by default, and this has been a part of the ALTA standards for going back to the late 60s, that this 0.07 of a foot plus 50 parts per million or 50 feet in a million feet, which is a half a hundredth every 100 feet, is your allowable tolerance between any 2 points on the survey. They're tweaking that in the 2021 surveys to be any 2 adjoining corners. So corners found or set, more specifically set, should not exceed this error tolerance we're talking about here. And so part of the job of the survey is to identify the right methodology to get the survey done. We talk about records and research, what has to be provided to the surveyor or acquired and then provided to the surveyor. Record descriptions, recorded easements, benefiting the property. Used to be that the language was the following lines: affect the property, and then they developed the benefiting and burdening language on the last go around because easements may do both, or they may only do one or the other. So that distinction will be made. Unrecorded documents, we talked about that a moment ago. There could be property line agreements that aren't in the record, boundary surveys, and then the Table A items, documents. We talked about this kind of briefly a little bit ago, that the survey by default would be performed on the ground unless we have a conversation about alternate sources of information, or if I identify those other sources on the survey. The second paragraph here talks about the appropriate degree of precision, and I kind of touched on this beforehand. It's supposed to be based on the planned use of the property if reported in writing to the surveyor. If I don't get that up front, or it's not explicitly stated, then it'll be based on the existing use, which may not be what you want. So if you ask me for an ALTA survey, expect to get that question from me: why do you want the survey? The rest of the field side here is there may or may not be monuments that need to be set, right of way and access need to be identified. The lines of possession, improvements along the boundaries. Not only am I required to survey improvements on the property, but I also have to locate improvements within 5 feet of the property to be sure that identify, because fences aren't really clear as to who set the fence or who did the fence. So any improvement within 5 feet of the property needs to be included as a requirement of the ALTA standards. Buildings will be located, visible evidence of easements of servitudes. If there are evidence of cemeteries on the property, or if you understand there may be cemeteries on a property, they need to be noted and the source cited for those, and water features as well. streams, lakes, ponds, other things like that.
Just quickly interject here, Steve, that even though the ALTA standards are really comprehensive and strict, that if there are any requirements by the individual states that are more stringent than the ALTA standards, then those stringent state standards would hold. So here in Virginia, for example, you do a boundary survey, you need to monument your corners when you're done. So that wouldn't be, I would always check that on table A, or if that's where the monuments placed requirement is.
Yep, good point. So yeah, your surveyor usually gets people up to speed with local requirements, and certain items may not be optional, like we talked about, either based on local jurisdiction requirements, or if you've got a HUD requirement, then they're going to dictate some additional minimum standards. So when we talk about the presentation of the plat or map, we certainly have to show what property evidence we found, used, or held to determine the boundary description, dimensions, and closure. It's been my experience that the description included in the title commitment is a cut and paste operation. That description should appear word for word, comma for comma on the face of the survey. One of the survey dilemmas is, but that's not the current description of the property, or that may be it may say part of the property. So the record description could be an older description, but may not be as comprehensive. But you're still required to show the one that's in the title commitment, because that's the property they're insuring. Quite often, if I describe the property by meets and bounds on the survey with bearings and distance, I will show what we call the record dimension, which is the deed bearing or the record plat bearing, and I may show the surveyed bearing on there as well, because older descriptions may have been prepared to a magnetic north or to a local jurisdiction. For those in Maryland who know WSSC, it might have been done in an assumed coordinates, but in WSSC datum. And now that GPS is widely available to the survey community, quite often these surveys are done in state plane coordinates, and the bearings may be rotated a bit. And so you might get a statement that the bearing shown here on is subject to a 2-degree rotation clockwise due to conversion from WSSC to state plane. So all of my surveys will have that type of statement on there, including record and measured. And we also put an affirmative statement on there that the property shown here on is the same property as described in the title commitment prepared by so-and-so. And so I make that affirmative statement, which goes a long way to giving assurance to the other players, the lenders and the title folks, that the property I'm surveying, including here, is the same property that they described and that they're insuring. And then obviously we're showing the easement, servitudes, rights of way, access, and documents. There may be items that cannot be shown on a survey, but we'll make those statements to that effect. So we usually break it down. The following items benefit or burden the property and are shown here on. The following items benefit or burden the property but can't be shown because they're not graphic in nature. Sometimes those are called blanket type easements. You can have a blanket easement for electric, older electric easements, service lines, where across the entire property I own at this address, and the old cards and that were filed don't give you any specific information, or they give you very vague information. Pole line extending from pole number south in a southerly direction 500 feet. And so it doesn't have a width and a length per se. It identified where they intended to put it. So to the best you can, that's how we're going to represent those on the survey. We also have some items that we get referenced in our section 2, the Schedule B, that aren't survey matters, and we'll identify them as such. They may be lease agreements, right of refusal, those types of things. Gene, anything on this part here?
No, but I just, now that most title reports are delivered in Word format, it makes it really easy to cut and paste it onto your survey, and then address each one individually as you go, so that you can see whether it's shown on the survey. So whoever's reviewing it can see whether that exception is shown on the survey or it can't be shown on the survey.
Yeah. And quite often, our policy here at CPJ is to, the number on my survey, I'll say the following items and I'll list them here. I don't renumber them. I use the number I use next to that exception is the same number in the title commitment. And not always, but quite often I'm asked to put that same label on the actual easement. So if there's a 20-foot sewer line running through the property and it's exception number 11, in the notes of my survey say, 20-foot easement to WSSC recorded in library and folio, and then I show it graphically. Of course, I'm going to have located the sewer manholes, and then in that same easement, it's going to say exception 11. So it draws the reader's attention to the easement item and where it's addressed on my survey. It's been our standard practice. We've had a lot of good success with that. All right. I always love this slide here. You can have a little fun with this, but I bet you most people can read this with a whole lot of ease. So I always tell my surveyors to spell check their documents because you can miss stuff, especially you're worried about the nuts and bolts of the contents of the survey, and you don't read all of your notes or the stuff you've written. One of the things we help, well, we'll cover the certificate real quick here, and I'll show you what some of the things we do to help minimize any of these errors with our QAQC process. So we talked about the certificate. This is in the ALTA standards, the following certificate, unaltered. So this is that certificate right here. And includes, and that's by default, the table 8 items are blanket, so those would be filled in. There are certain jurisdictions, Delaware is one of them, that does require a separate certification on the survey, and you are allowed to do that. What I used to find, especially early on when the 2016 standards came out, is that people said, this is the certificate I want you to use, and it was one from the drawer that used to be the practice from the last survey or the last good survey they did, but it's not acceptable on the 2016 ALTA standards. So what we did traditionally is added those items that they wanted in the certificate to the notes. So when I sign my name to a survey, all the items on the survey are being certified to. So if my notes include notes to the effect that certain items have been included on the survey, or whether it's utility outreach or whatever it is, those are on there. There's certain things I'd rather not put on there that probably my E&O carrier won't let me put on there. Used to be you get asked to certify that all utilities necessary for the operation of this property, either service a property through public rights of way or their point of access is shown on the survey. I may not know the answer to that. I can tell you what's out there. I can tell you what's in the record, but I can't tell you that all utilities or easements necessary for the operation of the property. So there's going to be some back and forth, but more often than not, items that used to be asked to be included in the certificate can be included as notes on the survey, and they have the same force and effect. One of the things we do as part of our QAQC process here at CPJ is to try to automate the process as much as possible. Now, this may look at like one of these, there's a handful of national survey firms that reach out to local surveyors and want you to do a survey on their behalf. We're not a brokerage firm. We're local to Maryland, DC, Virginia, Pennsylvania, and survey in these jurisdictions because we've got history and clients in this area here. But as part of our quality assurance and quality control, we've got templates. So the border is set up so that certain items can be filled in. My survey certificate is already I can load that in as a block. My utility statement's loaded in, my graphic scale, my legend, my curve table, my vicinity map, my legal description. These are placeholder items. And my notes, they'll be tweaked so that they can be, the data can be incorporated without inventing the wheel each time, right? So my notes, and this is one I did for a DC survey, this is a blank one, but all these items need to be on the survey. And I don't want somebody to forget. So I just put them in a standard text document. They get loaded into the survey, and then we fill in the blanks, these underscored areas. I've got some for my Maryland certificate that are replaced with just X's, 3 X's, 4 X's, something like that. So we're doing a spell check. They get flagged as a blank that I didn't fill in. This is what we use to make sure that we didn't forget to include a particular item that should be on the survey. And you'll notice in here, I have a couple catch-all notes that talks about no observed evidence of current earth-moving work, building construction or building additions, no proposed changes street rights-of-way. So I've addressed some of these other items in here affirmatively, and I don't get a whole lot of questions on this. So this works very well. I also include my standard utility statement, basically saying I can't see through the ground, that I'm going to show visible evidence of utilities, but I don't guarantee or warrant that all the utilities are in place either way shown. Although I do say that they're located as accurately as possible. And if we need to go to the next level of getting a subsurface utility engineer on board, then we'll do that. I also put this in my guys' hands, so we've got a checklist internally, so they know all the different items up front that they need to deal with, the various things, so they can check each one of these. Our reviewers of the surveys have this same list in their hands, so they're making sure that these items are in there. And we do review this on a regular basis, so it does get updated.
I think in addition to the internal QAQC process, sometimes you look at the plat for a long period of time and some obvious thing, you just don't see it. So I really appreciate, when the title company or the attorneys, notice something and let me know so we can get it corrected before it's finally done. And so they are become part of the QAQC process.
Exactly right. So I've got a handful more slides left, but I did want to make sure people, if you missed the very first part of our conversation, we talked about the Teams format here. If you hover over the middle of the screen where the presentation is, and there's an area, third button from the right that says show and hide conversation, if you want to type in a question or type in a message, we'll have probably a couple minutes left at the end of the hour here to address any questions that get put into that chat area here. The deliverable, as Section 8 on the ALTA survey standards here, this has kind of evolved. In the day, we've become a very electronic society now. Hard copies, we used to send out 2 or 3 hard copies on every survey we did. More often than not now, PDFs get distributed and they get signed and scanned, or they might get docu-signed or by whatever other electronic signing process you have. But more often than not, when the transaction's finally blessed by everybody, the lender is going to want 2 copies of the survey, and you'll get them packaged up and folded up and sent off to them for their records. And your client will want some. Certain jurisdictions require you to offer, to provide your 2 copies of your boundary survey to your client. And ALTA surveys in Maryland speak are boundary surveys, and in Virginia as well. So this is I mentioned 2800 V Street beforehand. This is one we did for them. So while you can't see a whole lot of detail on here, but this is what it might look like here. And so you'll see the same component pieces we talked about. Some of them are shuffled around from my blank template, but all the component pieces are here. And you can see the general format of most of my surveys. We surveyors sometimes through their professional organizations, societies, enter into plat survey competitions, and CPJ loves to have bragging rights sometimes, so we'll submit some for the Maryland Society of Surveyors ALTA survey contest. And a couple years back, the guy who was judging it called me up and said, he says, Steve, it says, all your surveys looked exactly the same. And I thought that was probably one of the best compliments he could give me, because I want them to look the same. The standard border, the guts are going to look a little different, but the notes, the title block, the legend, all that should look very much the same. It tells me that we've done our job on the QC part, and that we won't have left anything off. I want them to be standard. And when you pick it up, I want you to think it's a CPJ survey as well. So this is our perils and pitfalls portion here. Of course, I usually give this admonition when I'm talking to other surveyors preparing surveys. Don't be afraid to say no. There are times when you just have to say no. I can't do the survey in the time frame you're talking about. Is that negotiable? Everything is negotiable. If it's not negotiable, then they may need to find somebody else who says they can do it. Don't ever certify to something you don't know. And then don't ever do anything that your errors and omissions carrier won't cover. That'll get you into hot water real quick. Do use a contract on every job. We talked about the proposal that I sent out. That's the offer. And when it's signed by the client, there's the acceptance. And then as long as we've had those additional conversations, if we're doing something in Maryland, we've had the meeting of the minds, we've got a contract in place. Ideally, you only deal with quality people. Now, everybody on this phone call is clearly quality people, which is why you're in the know when you got our invite. And if you're not a client of CPJ, we certainly encourage you to give us a run on your next project if you haven't already. And then I can't stress this enough, communicate along the way. No news is bad news. What's the status of my survey? And all they hear is crickets. That's not a good sign. If you're 2 days out, 3 days out, tell them that. If you think you're going to hit your target date, tell them that. That's good news. If you don't think you're going to hit your target date from the surveyor side, tell them that as soon as you know. There may be some wiggle room on that, but keep the client, you folks, and the surveyor, that dialogue has to happen all along the way. All right, so some people may be typing in questions in here. I see one coming up here. We'll get to that in just a minute here. The one question I see so far is, what's your standard liability insurance coverage, or does it change depending on the type of project? It can change on larger projects. We usually go with $1 million liability coverage, and it talks about a handful of other things for vehicles and that sort of thing. But the $1 million number is thrown out quite a bit. Sometimes it's $2 million. If a certain client wants extra, I've seen some that want $5 and $10 million. We pay extra for that because, like Gene said earlier, we've got to go to our carrier and request that additional coverage for this project, and there's a fee for that, and then that would in turn get passed along as well. So we talked about what's next. Last year, actually since the 2016 standards went into play, the NSPS committee constantly receives and solicits comments on the standards and what they can do to improve them. And they get a lot of good comments, and they get a lot of crazy comments. Anyway, they sift through all these, and then the year before this new standards come into play, the two different groups, the NSPS group and the ALTA group, meet, which they did last year. And then the NSPS group met this past spring, and then the two groups get back together again, should be this month. I haven't talked to Gary about whether or not that's in play or not. And then later this year, the two groups will have the final draft. Each one of those groups, when it's all said and done, agree to that. And then the date they go into effect is February 23rd, will be 2021 this year. And it's been February 23rd for the last handful of cycles, and there's a good reason for that, but it doesn't really make a whole lot of difference. It's a yucky thing, terminalia for a bunch of surveyors, and like to hold it a February 23rd date. I do quite often give up-to-date seminars right after the February release or right prior to, so that to certain attorney firms and people who want specific presentations, so that you're up to speed with the nuances of the new ALTA standards. I don't see any significant changes in the new standards, but we can certainly set up something for individual folks as that date gets close, if that's something that you want to do. Of course, you can always reach out to us here. Gene and I are available by phone and by email. We'd love to hear from you here. I'm not sure if there's any other questions. I didn't see any in here. So I see one question here that says, I've been seeing more surveys with utility lines showing up that are not tied to record descriptions. It says, do you encounter this often? If so, it says, and if so, it says, what do you suggest? And I can't see because there's another message in there. So other than going to the fee owner to get information. So, we're not miracle workers. So if we have easement docs reviewed that can be shown on the survey, we'll time to the survey. If we have utility lines, and I see this more often than not, a storm drain line that shows up physically on the ground out on the field, but there's no evidence, a document for it, that quite often gets discussed in our I have clients that prepare title objection memos, and we have a group meeting between the title company, my client, and the surveyor, and we review all these items on the survey, and these items that we're talking about here, especially utilities that aren't included in an easement, will be discussed. and it's identified that maybe an easement needs to be had, or it's quite possible that the title report, and we didn't really talk about that too much. Back in the day, like I said, Gene and I have had 4 years experience in doing this here. You hear about 60-year title report all the time. Well, 60 years from now, from 2020 only takes you back to 1960. There are plenty of easements that went on record for properties that maybe didn't change hands back in the first half of the 20th century. Quite often, telephone utility lines went on board in the early 1900s. So you got to be careful. Just because your title report or the exceptions in the title commitment don't list a particular utility easement, the report may not have gone back far enough. So you need to know how far back that report does go, and if it needs to be requested to go back a little further to maybe more fully investigate some of these utility lines that aren't in an easement shown on the survey.
Well, some of the things that I see, Steve, down here, over here in Virginia is for Dominion Virginia Power, the successor to VEPCO. And I used to work with an attorney quite a bit that he used to call them ancient easements.
Yeah.
And they'd have a plat attached, and it would just look like just a little hand-drawn thing that didn't have any dimensions or anything on it. And so sometimes years go by and you can see that there's like an overhead power line that goes up to where a house used to be. And if you feel confident enough, sometimes I'll say, well, approximate location of easement, and then list the deed book and page. But in many cases, those plats that are attached are so vague, there's just no way of identifying. So you end up having the overhead lines on the site, but you just don't know if that is where the easement was intended to be 50, 60, 70 years ago.
All good stuff, Gene. I had another question here. It says, will the new standard result in surveys done with the 2016 standard result in the 2016 standard survey not being accepted by the lenders? So what happened when the 2011 standards became the 2016 standards, from the survey side, if I am already under contract for a 2016 survey, say you contract with me in January of 2021, and we've got plenty of time because the feasibility period is 4 months, because that happens all the time. I can perform and sign a survey after the February date that was under contract prior to the 2021 standards being in place. If we come under contract after 2021, then only the new standards will apply. And even if I'm recertifying an old survey, I've got to include the new certificate on there, because recertifying is a funny term. Recertifying is a term is quite often thrown out there with the hope of getting a discounted fee on a survey that was previously done by the firm. But in essence, each one of them is a new survey, because the site conditions may not be the same, or there may be newer exceptions, or the commitment's different. So recertification isn't just signing and sealing the new survey and out the door it goes with a new date on it, that a new set of documents will be reviewed, a new field visit will be had. But to the nuances of the date, that's my understanding. In 2016, if you run under contract for a 2011 survey and you didn't perform till afterwards, you can still sign and work to the 2011. And I suspect that'll be the same for the 2016 standards when the 2021 standards come out. All right, we were just past 3 o'clock. We've used up substantially the hour. I really appreciate everybody joining us today for our 2020 webinar series. Ignore the date on my last slide here. I changed that on the first slide, but today is Wednesday. Don't get lost in your week here. Reach out to myself or Gene. You have our emails up there, the Maryland and Virginia office phone numbers. We'd love to talk about your next project. If you're looking to switch consultants, or if you have good news or another project you want to bring our way, we'd be happy to talk to you about it. Having seen any other questions, Gene, you get the last word.
Just reiterate what you said, that we'd like to hear from you if you have any need for boundary or ALTA surveys.
A lot of thanks for this meeting goes out to Brad Bartell. He's in our business development area. He set this meeting up and a couple other webinars, and I really appreciate his support and allowing us in this COVID-19 environment, and I went all session without saying the word, to be able to bring some good information to you folks, and I hope it was a benefit to you all. Thank you all for coming out today, and look for additional announcements for future webinars.